Hi guys! Welcome to another episode of Attorney Javier's Philippine Law Lectures for Students. In the last episode, we discussed the birth of cooperatives, specifically incorporation, registration, capital, and shares as part of the first phases of the life cycle of a cooperative. For today's episode, we venture to a discussion on the midlife incidents of a cooperative, where it may either split, absorb or be absorbed, or join with another to form a totally new cooperative. So if you like my videos and you want to see more, please hit the subscribe button. A like on this or any of my other videos would also be greatly appreciated. Also, please remember that this is only for educational purposes and is not meant to be a substitute for proper legal advice or for studying and understanding the law. Now, let's begin with the division of cooperatives. Well, the components of a cooperative, meaning the members and the directors, they may decide for whatever reason to separate or to divide into two or more cooperatives, where the original cooperative is dissolved and the resulting cooperatives acquire separate and distinct juridical personalities, subject only to the limitation that the division of cooperatives should not be done to defraud creditors. Now, division may be done through a proposal from either a majority vote of the board of directors or by at least 10% of the members with voting rights. Now, this proposal must be approved by at least majority of the members with voting rights present and constituting a quorum in a general or representative assembly meeting called for the purpose. Upon approval of the proposal, a committee will now be formed for what? To formulate a plan of division. Now, this plan should include the justification or reason for the division, financial statement of the assets, liabilities, and share capital of the cooperative, list of creditors, procedure for the division of assets, and feasibility study ensuring the viability and sustainability of the new cooperatives, among other provisions, no? Further, the members of the original cooperative, they will be given 2 weeks to choose which one of the new cooperatives that they want to join. The management of the original cooperative, they will transfer the members' share and interests to the cooperative that they choose to belong to. Thereafter, the board will call a general or representative assembly meeting where the plan of division has to be approved by how much? By a vote of 3/4 of all members with voting rights present and constituting a quorum. Now, what if some members don't agree with this division, no? If there are members who do not agree with the division, the dissenting member will be entitled to a refund of his or her share capital and all other interests. Within 7 days after the approval of the division, the secretary of the cooperative shall publish the plan of division once a week for 3 consecutive weeks in a newspaper of general circulation within the area of operation of the cooperative. Alternatively, the plan may be posted in at least 3 conspicuous public places for 3 consecutive weeks within the area of operation of the cooperative. It is also required that notices of the division of the cooperative be sent to the creditors of the cooperative. Of course, radio and TV announcements are allowed, but publication or posting and notifying creditors are necessary requirements. They must be done. Now, the plan of division may be objected to or opposed by a third party. Within what period? Within 15 days from posting or from the last day of publication. Now, this objection must be resolved by the Cooperative Development Authority, or the CDA for short, within 60 days from receipt of the objection or opposition. Now, if the opposition is meritorious, then the CDA will either defer or disapprove the registration of the new cooperatives. However, if the period within which to file the objections has lapsed, with no objections being filed, or if all objections and oppositions have already been resolved, then the cooperative can now file its application for registration. Now, the requirements are the same as a regular registration of a new cooperative. However, the requirements, there are a few additional requirements in case of new cooperatives as a result of division. Okay? Now, these few additional documents would include a certified resolution of the division as approved by the assembly. Also, of course, the plan of division, financial statements, proof, of course, of the publication or posting and of the sending of notice to creditors, and the original certificate of registration, no, among other documentary requirements. Now, once the registration requirements are found to be complete and in order, the CDA will now issue the certificates of registration to the new cooperatives. Now, the certificate of registration of the original cooperative has to be surrendered to the CDA for cancellation. Because of course, the old certificate and the new ones cannot coexist. You have to cancel the old ones. Because again, the original cooperative was now dissolved, has been dissolved, because it had split or divided into into cooperatives with separate juridical personalities. Okay? So, same as with the regular registration, the new cooperatives acquire juridical personality only from the date that the CDA issues the certificates of registration. Now, if a cooperative can divide, it can also enter into mergers or consolidation. But this can only take place between cooperatives that belong to the same category. Meaning that only primary cooperatives can merge with primary cooperatives, secondary with secondary, and tertiary cooperatives with tertiary cooperatives only. Okay? Now, let's distinguish between mergers and consolidation. Merger is the union between two or more existing cooperatives belonging to the same category, where the surviving cooperative retains its identity while absorbing one or more constituent cooperatives. Okay? This surviving cooperative retains its identity, siya pa rin ito, while absorbing another one or more constituent cooperatives. Now, consolidation, on the other hand, is a union of two or more existing cooperatives belonging to the same category, forming a totally new cooperative called the consolidated cooperative. Now, both merger and consolidation share common effects. The first being, the constituent cooperatives will now become a single cooperative, which in the case of merger shall be the surviving cooperative, and in the case of consolidation shall be the consolidated cooperative. Second effect, the separate existence of the constituent cooperatives shall cease, except that of the surviving or consolidated cooperative. Third, the surviving or the consolidated cooperative shall possess all the assets, rights, privileges, immunities, and franchises of each of the constituent cooperatives. And fourth, the surviving or the consolidated cooperative shall be responsible for all the liabilities and obligations of each of the constituent cooperatives in the same manner as if such surviving or consolidated cooperative had itself incurred such liabilities or obligations. Okay? So take note that the fact that cooperatives may have been merged or consolidated, that fact cannot impair the rights of creditors. Neither can it impair any lien constituted upon the property of any of the constituent cooperatives that has been established before the merger or consolidation took place. Now, how is merger or consolidation done? It starts with a proposal from either a majority vote by the board of directors or by at least 10% of the members with voting rights of each of the constituent cooperatives. Now, the proposal that must be approved by at least majority of the members with voting rights of each of the constituent cooperatives. They have to be present and constituting a quorum in separate meetings, okay? Separate general or assembly meetings called for the purpose. During that same meeting, the respective members of each of the constituent cooperatives will now appoint or elect representatives to the joint committee that will be tasked with drafting the plan of merger or consolidation, okay? And after their election or appointment, the joint committee will now formulate the plan of merger or consolidation, which shall include information such as the purpose of the merger or consolidation, the details of the cooperatives and its members, among other information. Okay? But one thing to note is that in the case of merger, since one corporation is absorbing another, the plan should include the proposed amendments to the surviving cooperatives' articles of cooperation and bylaws. While in the case of consolidation, the proposed new articles and bylaws of the new cooperative. Okay? Why? Because in a merger, since one cooperative is absorbing another, you don't need a new set of articles and bylaws. You can simply amend the existing one of the absorbing corporation or the will-be surviving corporation, cooperative rather. No? In the case of consolidation, you need a totally new set of articles and bylaws. Why? Because remember, consolidation involves the union of two or more existing cooperatives to form a new cooperative. So it also needs a new set of articles and bylaws. Okay? So thereafter, the plan, including the amended articles in case of merger, or the proposed new articles and bylaws of the new cooperative, must now be approved, okay, by the affirmative vote of members representing at least 3/4 of all the members with voting rights of each of the constituent cooperatives present and constituting a quorum, again at separate general or representative assembly meetings called for the purpose. After approval, the announcement of merger or consolidation must be done in the following ways. No? First, by letters sent to the respective creditors of the constituent cooperatives. And second, publicly, either by posting in at least 3 conspicuous places in their respective areas of operation or publication in a newspaper of general circulation once a week for 3 consecutive weeks. Now, of course, radio and TV announcements are allowed, but similar with division, it is necessary to send notices to creditors and to either publish or post the notice of merger or consolidation as the case may be. Now, third parties are given 15 days from posting or the last day of publication within which to file their objections or opposition to the plan of merger or consolidation with the CDA. And the CDA must resolve these objections or oppositions within 60 days from receipt. If the opposition is meritorious, then the CDA shall either defer or disapprove the registration of the merger or consolidation. However, if the period within which to file objections has already lapsed with no objections being filed, or if all objections or oppositions have been resolved, then the cooperative can now file its application for registration. Now, I will no longer go over the list of documentary requirements for the application for registration, as this is a very long list, no? At least 13 or 14 documents each for merger and for consolidation, no? 13 or 14 for merger, 13 or 14 for consolidation. Anyway, if you really plan on merging or consolidating your cooperatives, if it's a real world concern, you can just inquire with the CTA, or you can hire a lawyer, okay? And you can also read the law, no? It's also in the law. Now, once the registration requirements are found to be complete and of course in order, then the CDA will now issue the certificate of merger, or in case of consolidation, the CDA will issue the new certificates of registration for the new cooperative, okay? And the certificate of registration of the original cooperative will have to be surrendered for cancellation, okay? Again, the old certificate cannot coexist with the new certificate of registration, okay? So that's it for the incidents in the middle of the life that may take place in the life of a cooperative, no? To find out what happens in the end stages of the life of a cooperative, or how to terminate the existence of a cooperative, stay tuned for the next episode. Okay? So, I hope you may have picked up a thing or two, and I hope to see you soon, guys. Bye!